We've spent a lot of time this semester talking about how the Supreme Court goes about making its decisions. Now, however, we're going to turn our attention to what happens after the Supreme Court makes a decision. This is a subject that isn't usually covered in most constitutional law classes, where you just read the decision and analyze it and that's it. But this is judicial politics, and so what we're interested in is what happens after a decision. How does that decision get put into effect? And this is an interesting question because the Supreme Court has no regular way to enforce its decisions. It announces something, it tells the other branches of government or a state government that it has to do various things, but the court itself has no army of administrators or even a regular army to make sure that its decisions are carried out. It has to wait on appeals if people aren't carrying out its decisions. So the court doesn't monitor compliance with its decisions. If the court says that something needs to be done and that thing isn't done, then somebody else has to file another lawsuit, and then that may take a significant amount of time. And so the court is reliant upon others, and this is, by the way, one of the reasons why the court stresses its legitimacy as much as it does. It has to rely on other people to carry out its mandates, and if those other people do not see the court as legitimate, then it may be less likely that they will actually carry them out. So when political scientists examine the implementation of Supreme Court decisions, they tend to categorize the society into three different populations. And so we're going to talk about these three different populations in this lecture. One is the interpreting population, the second is the implementing population, and the third is the consumer population. So every Supreme Court decision has all three of these populations that are affected. So let's explore the difference. First, the interpreting population. Opinions, of course, themselves are acts of interpretation. We've talked about this. This is what the court does. They interpret the Constitution, they interpret statutes, and so the opinions that they release are themselves interpretation of the law. But the Supreme Court will never go out of business, because not only does it have to interpret laws and the Constitution, but every time it writes an opinion, that opinion itself requires interpretation. Every opinion that's created creates new ambiguities, it creates new questions that require interpretation. And there are some individuals out there in society whose job it is to interpret what the Supreme Court has said. These are individuals who are in an official position to give guidance to others, and so they are very, very important in determining how others perceive of the decision and what other people think they have to do in order to comply with the decision. Now, the interpreting population is fairly consistent no matter what decision we're talking about. The other two populations will vary from decision to decision, but the interpreting population is the same pretty much regardless of what decision we might be talking about. So who is it out there whose job it is to interpret what the Supreme Court has said? Well, one group of individuals who are part of the interpreting population is, of course, lower court judges. Lower court judges decide new cases that rely on Supreme Court precedents, and when they decide those cases, they are interpreting those Supreme Court precedents. Attorneys General, so that could be the Attorney General of the United States, but more importantly, probably state attorneys general. Attorneys General are, one of their duties is to read court cases and figure out what the state or the federal government is required to do, how they are required to comply with a particular court decision. And in fact, part of the resistance to Brown v. Board of Education was because attorneys general in the South essentially said, well, we don't need to do very much to comply with Brown v. Board of Education, and so of course that gave legal cover to everybody else in the system to obstruct the court's decision. Lawyers generally are part of the interpreting population. Of course, attorneys general are the official lawyers for the government, but everybody who might be affected by a case, their lawyers are probably talking to them about what the court has decided and what it means for them. So lawyers are certainly part of the interpreting population. And law professors are another group that's in the interpreting population. They write lots of law review articles that try to explain the implications of court decisions. And in fact, we could probably include this to include journalists as well. There are journalists who are not law professors, but they write in popular journals and newspapers and magazines, and they try to explain what the court has done. So all of these people are part of the interpreting population, and again, as you can see, it doesn't matter whether we're talking about search and seizure or affirmative action, you're going to have the same interpreting population kind of across the board. The implementing population is, of course, the individuals who are actually responsible for carrying out the decision. So the interpreting population says, here's what you have to do, and the implementing population is the population that actually has to do it. Now, some decisions don't require any action at all, and so there may or may not be an implementing population if no action is required. For example, Roe v. Wade simply said women have a right to abortion. It wiped abortion laws off the books, and it didn't require any action on the part of state legislatures. However, of course, many state legislatures afterwards still reacted to the decision and passed laws trying to test the court's resolve. So the implementing population is, it can vary widely depending on the issue, of course. Different cases involve different segments of American life, and so the groups of people who are responsible for carrying them out is going to differ. And so just some examples, almost anybody could be part of the implementing population, but many decisions, for example, the court decides have to do with police procedure, well, when they can conduct searches and seizures. And so the police are often a part of the implementing population for those kinds of decisions. Teachers are responsible for example, school prayer decisions. The Supreme Court said in the 1960s that you couldn't have school prayer, and yet some teachers nevertheless continued to pray in their classrooms. And there are other decisions that affect things that go on in the classroom, and so of course teachers or school administrators would be part of the implementing population in those kinds of cases. Administrators generally, of course, that's a general term. Elected officials may be part of the implementing population. For example, a court may order the state to relieve prison overcrowding because it violates the cruel and unusual punishment clause. The court itself will not be the one who figures out how to do it. It would be elected officials that would be given that responsibility. So again, the implementing population can vary widely, but typically, although not always, they're going to be individuals in government who are in some source of official power. And then finally, the consumer population. The consumer population is the broadest population. These are the individuals who bear the consequences of the policy. Now, these consequences could be good, they could be bad. Some Supreme Court decisions provide individuals with rights, others may provide them with duties, but regardless, the consumer population is the group that will be affected if the decision is actually implemented. And the consumer population really varies quite widely depending on the issue. And we'll just take a few examples. Let's take a look at these 4 cases and figure out, who would the consumer population be for each of these cases. In Miranda v. Arizona, of course, the Supreme Court said that if you were arrested, you had the right to have your rights read to you. So who would the consumer population be for that? Well, it would be anybody who is arrested for a crime. And of course, the implementing population would be the police. How about Roe v. Wade, the decision that gave women the right to an abortion? Well, of course, women, all women, except perhaps women who are past childbearing years, but most women would be part of the consumer population of Roe v. Wade. How about Obamacare, where the court upheld the constitutionality of the individual mandate? Well, in this case, everybody in the United States would be the consumer population. So you can see the consumer population can be very, very large. And Bakke v. University of California, where the court struck down the UC Davis Medical School Affirmative Action Program. Of course, there the consumer population would be students. So as you can see, this is the largest and most varied of the categories. Well, in our next lecture, we're going to talk about the fundamental question of why do some decisions get lots of compliance and acceptance, and why do some gender extreme opposition.